Hello everybody, welcome back to my YouTube channel. This is Shireen Kapoor and I'm joining you from East Laws Dubai office. So today I'm going to discuss with you a very sensitive topic when it comes to Canadian immigration, in which a lot of people directly, indirectly, intentionally, unintentionally get trapped, and then they are like in a jinx. They don't know what to do, and sometimes they are out of remedies. And how can you take care of this? What are the precautions you can take from the very beginning? What are the steps you can take in between? And then of course, what are the end remedies for you? So I'm going to discuss everything about misrepresentation when it comes to Canadian immigration. So misrepresentation is a very sensitive law, and the law states under section 40 of the Immigration Refugee Protection Act, it says that if you directly or indirectly withhold any material information that can conduct an error when the administrative officer is determining your decision, it amounts to misrepresentation. So misrepresentation definition is so broad that even while filling a form you forget to tell about your past refusal amounts to misrepresentation. And the misrepresentation in law can extend your punishment up to ban of 5 years to apply again to Canada, unless you can satisfy or there is a proper hearing that you've done or a proper redetermination of your case. So there are remedies available. It's nothing like a black hole. Of course, it is something which not everybody understands, that how the law unfolds, but it is not the end of the world. Like, there are remedies out there and there is a way of dealing with the misrep situation. Now my first part of this video, by the end maybe you will of course be educated about the whole process, but my first part of the video I'm going to tell you about what exactly misrepresentation can be. Like, I'm going to give you some examples. Recently I dealt with a case in which a couple was living in together within Canada for about 12 months, more than 12 months, and they had been declaring in their post-graduation work permit form that she sticked no to the common law relationship or the marriage. So she said that she's single. Now this is misrep, because later when the officer got to know through another form or through another possible document that of course they were living together, their driving license, everything was on same address. So obviously this is a tight situation for the client, and the client has no way of explaining it except to the fact that we had to take the defense of innocence. Now defense of innocence also I will explain. It is a very narrow defense of misrep, but it can be taken into account when you come on to misrepresentation exclusion hearings. So what misrepresentation can lead to? It can lead to you being inadmissible to Canada. It can also lead to a hearing of misrepresentation wherein you have to present yourself in front of the judge along with the Minister's Council. It can be a proper exclusion hearing as well. So it is kind of a tricky situation. For example, also I can give you an example. Sometimes a lot of time, in fact, you tend to forget that you had past refusal, the US visa was rejected, UK was rejected, blah blah, any kind of past refusal which you don't amount and you do not mention in the Canadian immigration forms when you're filling them. That is again a problem for you. Later on the officer will come and say, okay, we have information sharing with all the countries in the world, almost all the countries in the world. Canada has information sharing. So if you have not declared that rejection part, of course they know it in their system of internal checks. So then that can amount to misrepresentation. But before everything happens, there is another step. By law, by the jurisprudence, by federal court judgments, there is another step that the officer has to take. Now if the visa officers, and you are outside of Canada right now, and if the visa officer is assessing your profile and thinks that there is a glitch, there is a slight chance of misrep, maybe because you didn't understand common law relationship, you didn't understand the past rejection, you didn't understand any part of the form, and you misrep intentionally or unintentionally, but they are supposed to send you a letter called the procedural fairness letter. One of very important cases in the Canadian history of immigration is the Baker versus Canada, in which this PFL letter was discussed in detail. Now, why procedural fairness letter is such an important part is because it is your last chance and probably your first chance to explain everything that happened in your situation. So the PFL letter has to be very beautifully crafted with competent and compelling reasons, stating that why your letter, why you forgot to disclose this information, or why your document was fraud, or why it was forged, or why your university was, for example, some clients we have dealt in the past had a problem wherein their university later got disregarded by the Delhi government or some government, I don't remember exactly, but different governments. But then of course because those universities were banned, the immigration said that this is a document of that education is a misrep. So we have to, in different situations, come up with different arguments, explain that why there is a possibility of misrep and what happened wrong and how can we rectify it. So the PFL is a very, very important document which you have to reply to. There are certain days you have to reply within it. Usually I always suggest that do not deal with the PFL on your own, because if you are not crafting it beautifully, compelling reasons, argumentative, then there's no point putting the PFL letter. You should take assistance of some consultant or some lawyer who can help you and assist you with this process. There are most probably two types of situation and you can be stuck. For example, one is you have applied from outside Canada and the misrep has come from outside Canada. Now for that, of course, you get the PFL letter from the visa office. You have to explain it. If they still don't buy it, then you have to, of course, go for judicial review, because you're outside Canada and your next only option to remove the ban from your name is go for judicial review to Federal Court of Canada, and for that obviously you need a lawyer. Now the most common defense when somebody takes, and this is one of the only defense available to section 40 of misrep, is the defense of innocence. When you say that maybe because of some innocence or some kind of not fault of yours, in which you are not at fault, something like that has happened, and because of which you didn't intend to withhold any material information. Now one day, for example, I can give you a case in which, for example, the wife, she could not find her ex-husband had died, or maybe she could just not locate him, and hence it had been about 20-25 years. She got remarried and everything, and from outside Canada she had applied for a visitor to Canada. Now what happened is that they said, no, you have previous marriage and you did not declare it, so she had to present. Now this is an innocent because there is no motive of her hiding that information, so there are very the defense is very narrow. Please keep in mind, you cannot take this defense for everything. If you don't understand common law relationship definition, then okay, you have to prove that in terms of your documentation support that for example, defense usually we take when people don't understand is the common law relationship is a defense in we didn't understand the language, because it's a terminology which is not very common in the eastern part of the world. It is a more western concept. But having said that, you have to prove all your innocent defense through your documentation. It is one of the most common defenses people try to take, but then again its approach is very, very narrow. Even if you forget to declare for your relationships, your past relationships, anything, your visa refusal, anything you forget to declare, it will amount to misrep. So we have to be clear from the beginning that the PFL letter is your first step, and then if you go to the stage of judicial review, then of course defense of innocence is there, but it's a very bleak chances and will depend case to case basis. So my whole idea of making today's video was to make you wary of the fact that it looks a simple process. Everything is very simple, but with Canada, documentation, I again repeat, is one of the most important thing, and they rely on what you state in your documents, because at the end of the form, each form, you put your signature, and if you're taking help of the a rep or anybody, then you fill in the use of rep form. So of course you cannot blame it on your consultant if you are filling the form on your own, right? So you have to be sure that all the information you put is up to date, does not mislead, is not negligent. You are careful with everything, because any other program that you apply later in life, this will reflect back. And what information once you give to the Canadian immigration, you have to be sure that it is standardized in all other later applications, because later if they find out there was a degree you didn't mention, there was an education or an experience you didn't mention, that will also amount to misrep. So misrep is very easy to get. So be careful, be cautious, take the help of maybe professionals to help you navigate your immigration journey. Thank you, and keep watching for more such content.